Good morning, everyone. Welcome to the continuation of our hearing from yesterday. It is August 20th, 2026, and this is the Energy and Carbon Management Commission. Before we get started, do any commissioners have questions or comments before we begin? Okay, then I think Mr. Smeltz, we're ready for a roll call and to elevate the parties.
Thank you. Commissioner Ackerman?
Here.
Commissioner Cross?
Present.
Commissioner Mesner?
Here.
Commissioner Oath?
Here.
Commissioner Robbins? Chair, you have 4 of 5 commissioners present.
Wonderful. Thank you very much, Mr. Smeltz. Okay, I see Mr. Willis. I want to make sure that Mr. Prescott and Mr. Schwarzenegger are here as well. Perfect. Okay, now that we have everybody up, again, this is a continuation on 3 consolidated dockets. They are 251, 200, 254, docket 251, 200, 257, and docket 260, 100021. As we get ready to start, do any of the parties, council, have any procedural matters they need to address?
Nothing from applicant. Thank you.
Good morning, Commissioner Cross. This is Rob Willis. I do have a response to Commissioner Messner's questions from yesterday that I can make at your invitation.
Okay. And that's where I wanted to begin. I wasn't sure if I didn't see any written submissions come in, so I assumed it was going to be through testimony. So I just wanted to make sure we didn't have any other procedural matters before we got to that point. So seeing none, I will recognize KP Kaufman. And again, with Mr. Prescott having the ability to cross-examination in response to the questions that Commissioner Messner raised yesterday. So please proceed.
Thank you, Commissioner Cross. In response to Commissioner Messner's request for information from KP Kaufman related to the consolidated flow line located at the firecracker facility, the consolidation flow line leaving the facility was put in place by Amoco in the 1970s. The facility is in use today in that crude is from producing wells flowing to the facility flows to a hub device located near the inlet to the separator at the facility. On July 18, 2022, all crude was directed to the consolidation flow line, where the crude then flows from the facility to an alternate downstream facility for processing and subsequent sales. That's the statement I was instructed to read today from the client after talking to them.
Wonderful. Thank you. Mr. Prescott, do you have any questions of KP Kaufman?
Can I hear that statement read one more time?
Sure.
That'd be really helpful. Thanks.
You bet. In response to Commissioner Messner's request for information from KPK related to the consolidation flow line located at the firecracker facility, the consolidation flow line leaving the facility was put in place by Amoco in the 1970s. The facility is still in use today in that crude from producing wells flowing to the facility flows to a hub device located near the inlet to the separator at the facility. On June 18, 2022, all crude was directed to the consolidation flow line, where the crude then passes from the facility to an alternate downstream facility for processing and subsequent sales.
Thank you, Mr. Willis. Sorry to ask you to read that twice.
Sure, that's right.
Couple questions. First, I want to make sure I got that right. So consolidation line was installed by Amoco in the 1970s.
Yes.
And a consolidation line is essentially a gathering line, right? Where a bunch of different flow lines flow into.
I think that's true, yes.
Okay. And then you said something happened in 2018.
Yes.
What happened in 2018?
A valve was turned at the location near the separator. There's a hub there which collects some of the crude that flows into the facility. All crude then was diverted to the consolidation flow line on that day and has been since.
I thought that was in 2022 that crude was then directed to a consolidation line.
I think that's what I said. Hopefully I
Okay.
didn't misspeak. July 18, 2022.
July 18, 2022. So nothing happened in 2018. It was July 18, 2022 that this happened.
Correct.
And as I understand, the only thing that happened was a valve was turned to change with the oil flowing into
This,
the separator to then
Yes.
flow into a consolidation line?
correct. It redirected the crude from going through the processing equipment on the facility, on the firecracker facility, directed that to the consolidation line, where in turn that crude passes downstream to an alternate facility.
Okay. And help me understand that. So is the valve before or after the separator?
The valve is before, it's at the inlet to the separator, so it's before the separator.
Okay. So you have flow lines for all these wells going to a single line, which then goes into the separator. Do I have that right?
Correct.
And then before that separator, for reasons, why would there have been a line before the separator going to the consolidation line prior to 2022?
That was part of the system that was set up from Amoco. They wanted to use alternate facilities, and I think it's safe to say that KP Kaufman still enjoys the use of that comprehensive system where they can divert processing from the firecracker facility to alternate facilities and in kind too, between other processing facilities.
And I want to jump in here quickly. I apologize for interrupting. But as we're getting into a little bit of attorney saying, I think it might be to have one of the witnesses from KPK come to provide assurances instead of
Yes,
attorneys
it's hard to cross-examine the attorney. Yeah.
I don't know if Jeffrey Kaufman is available to be elevated. He might be the best person to speak to this.
We are elevating right now.
Perfect.
I guess to be clear, Commissioner Cross, my understanding of the question posed by Mr. Mesner, or Commissioner Mesner, was more related to timing than, the schematics and configuration. So we didn't have a lot of those details, but
Well, and I don't want to put words in Commissioner Messner's mouth, and I do think that timing was a big part of it, but I think the understanding of there's obviously been some uncertainty as to whether these wells are still producing. There's been some argument back and forth on that. So how they are still producing, where they are going, and how long they've been producing to that other facility. And so again, I do think this is relevant to try and make sure that we get a full understanding of this. And obviously I'll leave to each party how they want to address in closing arguments, but I just want to make sure that we have a clear record on this. I do see that Mr. Kaufman has been elevated here. So if he could visualize, I will remind him that he remains under oath. And I think we'll do it this way, Mr. Willis, I'll let you kind of do a new direct of him specifically with respect to this issue and any cross-examination attended.
That's fine. Thank you. Mr. Kaufman, can you hear me?
Good morning.
Good morning. How are you?
I'm okay. How are you?
I know you were paying attention during yesterday's hearing, and there was a question that was posed by several questions that were posed by Commissioner Messner with regards to the crude as it passes through the firecracker facility, how long and when that crude had been processed by equipment at that facility. Could you kind of describe, or could you now describe to the commission what occurs to that crude at the facility and when and if that diverts somewhere else for processing or sales?
Well, I think you described it accurately. In the way that Amoco had designed the system, the flow lines come in to a header, and there is piping that allows the crude to flow into the consolidation line. So we have that flexibility because of Amoco's design.
And for crude that goes through the facility and is processed at the facility, was there a time when it had to be diverted to an alternate facility for processing?
Yeah, so to answer Commissioner Messner's question, I think that your date was correct,
Right.
7/18/2022.
All right. Thank you. No further questions.
Thank you. Mr. Prescott.
Thanks, Mr. Kaufman. Sorry you had to come back today. Thanks for being here. So I assume you heard the back and forth I just had with Mr. Wilson. Appreciate that you're kind of stepping in the shoes here. But am I understanding correctly that what we're hearing today is that Amoco had installed a consolidation line, which is, do you agree that's effectively a gathering line?
No, I think it's akin to a flow line.
Okay. So thank you for that clarification. So Amoco installed a flow line in the 1970s. And approximately where's that flow line? Where does it start? Where does it end?
So they're all registered on the ECMC website, and if you click around, you can see exactly how it connects and how they're related.
So you don't know where that consolidation line starts and ends?
Yeah, I do.
Can you tell us?
How would you like me to describe it? I mean, I think that visual is the best. That line starts at the firecracker battery and goes up north to the facility.
And okay, help me understand that. So there's a consolidation line that starts at the firecracker tank battery and goes to another facility. And what I'm not understanding is why that would exist. Why do you have one facility that has a flow line going to another facility?
The way Amoco designed the system.
Okay, so KPK just happened to be in a situation in 2022 to stop using the firecracker facility because the flow line connected to these wells in the firecracker facility had another line going to another flow line going to another facility. Is that the explanation that I'm hearing today?
Well, yes.
Okay. And then all I've heard about is crude. Where's the gas going? We know there's a DCP takeaway at the firecracker. We know that's been abandoned for a long time. I haven't heard any discussion on where gas is going today.
It is three-phase.
So when you say crude, you mean crude water and gas?
Correct.
Okay, I understand. No more questions.
Thank you. Any redirect?
No, thank you.
Commissioners, I do want to open it up to you, as I know this stemmed from questions that Commissioner Messner raised yesterday. Commissioner Messner.
Good morning. Thanks for providing the information. Just a couple of clarifications. So up until 2022, the firecracker facility was utilized for all production that occurred prior to that point.
Yeah, that's a broad assumption. I know it was used by us for many years. Whether or not it was how it's been used in the past. I can't speak to, but
Yeah, I'm only speaking to your use, right?
Yeah.
So you've utilized that firecracker facility for any production up until 2022, at which point you shifted the gathering lines to go to a consolidated line from the firecracker to location four. Am I saying that right, or is it facility four? Um, and this is what's been utilized for production since July 18th of 2022, at which point there's been no production occurring at the firecracker facility. Is that fair to say?
well, the tank system has been uh, out of use, but there are portions of the facility that it has to flow through.
But this is flowing, this is getting transferred before the separators, right?
Before the separator, but there's a header system and piping and
Okay. Um, and I guess the last question I'll ask, because I'm still trying to get my head around it, is how many wells were going to the firecracker? I have a general idea of that one, but it's unclear to me now that you've diverted everything from what would typically go to the firecracker to location four. How many wells are, I guess, tied in now to location four?
I think the firecracker was 23 wells. Four is broken out into several different separators, so there are different measurement points there. Um, now going to that facility, you'd have I don't know, I'd have to count. It's actually not proportionally a tremendous number of wells, although there's how it's all plumbed is all very interesting. But there are, but again, there are multiple separators and multiple measurement points at four.
Okay. But the ones coming from the firecracker facility have the unique measurement point, or no?
It is commingled with some, other wells. So it does pick up some additional wells, but it's not, again, proportionately, it's not a tremendous number. We'd have to look up that number.
Okay, thank you.
Thank you. And I'll ask one clarifying question as well. And given that this was constructed by Amoco, maybe you know the answer, maybe you don't. I think a redundancy system makes sense, and that's what it sounds like this is. I'm a little curious with everything being diverted. It sounds like facility four was the redundancy, while the firecracker facility was the primary. I guess let's start there. Is that the case?
Yeah, I think you're right. I I guess I do think that I mean that system was all initially tied in, and how and when they constructed the individual facilities, I don't know, that all occurred in the 70s, but yes, it allows for use of multiple facilities. And similarly, the way the software works, each well you put in the individual well test from the test separator, which is, a piece of equipment on a trailer that we were able to take out, hook up to that individual well, get that measurement, and then, we put it into this software that, I mean, the software is used by Fortune 500 companies. Again, it's kind of a major, SEC compliant accounting software.
Okay. And the question I want to get to is if the firecracker facility was likely the primary facility before, do you know whether the flow line, that consolidation line, was ever used in the opposite direction, meaning was the oil and gas that was sent to facility 4, was that at one point in time also sent to the firecracker?
No, I don't think it would flow back that way.
Okay. I just wanted to make sure I understood. Other commissioners with questions? Commissioner Oath.
Thanks. Just one question, which is just want to understand what was going on in 2022 that sort of led KPK to turn that valve and send the production from these 3 wells or all 23 wells from the firecracker to facility number 4.
I think it was for air compliance reasons. It's to not that the firecracker has any problems, but rather it allows us greater control over inspections and monitoring and things like that.
So it was because it would mean less like you wouldn't have to do air quality monitoring at the firecracker facility anymore?
Not at the same frequency as the downstream facility.
So they're both still permitted sites?
I would imagine, that's a good question. I think the volumes are so low or non-existent into the tank system at the firecracker that it would no longer require a permit.
Okay. Okay, thanks.
Which, puts it on an annual inspection. So it still, I think, would be on the annual, but not anything greater.
Okay.
Any further questions from commissioners? Okay. Well, thank you, Mr. Kaufman. Again, I appreciate you reappearing here, and I think it was a little bit cleaner to make sure that we had a witness so we could get the proper record here as opposed to attorney testifying. So thank you. With that, that would be the close of each party's case in chief as well as the rebuttal case. And so the next up on the list would be the closing statement from KP Kaufman.
I'm sorry, Chair. Can we take a 5-minute break to see if I have a witness that has any information responsive to what we just heard for the first time?
Sure.
That'd be great. Thank you.
Okay. It is 10:40, so let's return at 10:45.
Thank you so much.
Okay, it looks like we have everybody back. Mr. Prescott.
We moved to closings. I wasn't able to get in touch, so we'll move on.
Okay, then I don't know if it's going to be Mr. Willis or Mr. Schwarzenegger. Okay, Mr. Willis, you were recognized for closing statements.
Thank you, Commissioner Cross. May it please the commission and opposing counsel, I'd like to just begin my summation by again revisiting the relief requested under the applications. This all relates to the Graham 3, or at least the applications relate to the Graham 1 well, the Firecracker Unit 1 well, and the Stonebreaker 4212 well. Each of these applications requested the commission determine that the well is no longer used or useful as defined in the 100 series. Also determine that the well poses a threat to public health, safety, welfare, and the environment. And order KPK to plug and abandon the well and its location within 12 months. The questions raised by the applicants are twofold. Has the applicant demonstrated that each of the subject wells is no longer used or useful? And has the applicant demonstrated that plugging and abandoning is reasonable and necessary to protect and minimize adverse impacts to public health, safety, and welfare? Again, the 2025 proceedings under docket number 2409-00228 with the resulting order number 1404 consumed multiple hearing days and dealt directly with one of the wells at issue here, and that's the Firecracker Unit 1 well. The application filed by Dacono on the Firecracker was denied. So the commission necessarily found that it was used or useful, and that plugging and abandoning the well was not reasonable or necessary to protect public health, safety, welfare, or the environment. Despite this, just 2 months after the written order denying the application on the Firecracker well, Walton filed its Rule 211 application, and in so doing used the same attorneys and expert witness. The commission should summarily deny the present application relating to the Firecracker well. 2 months of additional increased production hardly establishes new facts under the used and useful standard for that well, which has been producing for decades. And all of applicants' public health, safety, and welfare testimony and other evidence in this case is from May 2025 or October 2025, the very time when the 2025 order was entered. The commission should recognize the binding effect of prior adjudication to maintain integrity of the agency's prior fact-finding and determinations. However, setting aside the res judicata, collateral estoppel, notion assertions for the Firecracker well, the applications are not well-founded substantively. On the used or useful analysis, the applicant's expert utilizes production data only through February 2025. In so doing, the applicant ignores workovers and repairs performed on each of the wells that enhance production. You heard competent, uncontroverted testimony about the nature of the work performed and the subsequent production test resulting to measure daily production from each well. The applicant was provided this data in time to seek permission to amend its economic experts' reports, but has declined to do so. Instead, asserting without any evidence that the reported production is suspect or manufactured for some nefarious purposes. These assertions and innuendos are incorrect and not supported by any credible evidence, and do not carry the heavy burden of proof which Walden shoulders. Ultimately, uncontroverted evidence shows the KPK worked over and repaired each well, performed independent production tests to ascertain what, if any, incremental production increase was attributable to each well, to modify any apportionment needed in its production reporting for each well. Walton's tact of questioning the validity of the results or ignoring the new production volumes is disingenuous and does not carry their burden of proof under the applications. Now, regarding the public health, safety, and welfare component, the entirety of this aspect of Walton's 211 case hangs on the premise that issues in dispute at the excavated area at the Firecracker production facility call for the plugging and abandonment of wells upstream from the facility. Like many of the wells in the 2025 case, where this fact pattern was presented, there were no issues with the off-location wells themselves which could justify plugging and abandonment. As in the 2025 case, the commission should rule that problems at the downstream facility, which were attended to by KPK, resulting in a subsequent request to ECMC to backfill the open excavation and establish monitoring wells to assess possible groundwater contamination, do not justify the plugging and abandonment of wells upstream from that facility. However, KPK must ultimately move forward with ECMC to break this stalemate, closing that remediation project. While KPK appreciates Commissioner Messner's discussion on inactive well, KPK did not miss nor have the rules required MIT on these wells. And KPK is compliant with Bradenhead monitoring and annual reporting. These wells are otherwise compliant with ECMC rules, as you can tell by revisiting the recent exhibits provided by KPK with regards to weeds and any other issues that might be concerning at those facilities or those locations. Here, as mentioned in the 2025 proceeding, the Commission has only, in the most rare occasions, invoked Rule 211 or its predecessor rule, one being OFV IV 794 involving Black Resources, a well emitting H2S for decades, which did not have equipment to properly manage the H2S and no infrastructure to get it to market. There was no federal access for its operation. So it was a proper invocation of the rule. Also, order number 1303 related to Vision Energy resulted in a stipulation with Vision a stipulated order where Vision Energy's Bradenhead was venting into a tank and the tank was open. This actively emitting large amounts of VOCs into the atmosphere. This resulted in a stipulation with Vision Energy to plug and abandon that well. These cases, coupled with the denial of last year's application on public health, safety, and welfare grounds, demonstrate that the following exists. Consistent with the statement of basis and purpose, relief under 211 is extraordinarily rare. Only one occasion where it was not stipulated. And plugging and abandoning the well was reasonable and necessary to address impacts, and here there are none. And like last year's proceeding, this is another Rule 211 case brought by a developer in lieu of condemnation. Walton's concurrent use of Rule 211 is not proper, as the Commission found in the 2025 proceedings. Walton is considering, and in fact is fully capable of and likely on track to form a metro district under Colorado statute. Should this avenue be pursued, they could seek condemnation of KPK's property. Rule 211 does not offer a backdoor route to effect a condemnation, as condemnation proceedings are the known method under the law for developing alternate use plan over another's existing real property rights and uses. The Constitution requires just compensation. Condemnation statutes are designed around that concept. Rule 211 offers no such protection. So the mere fact that these applications are submitted by Walton to its development plans, which includes a request to P&A these 3 KP Kaufman wells, establishes that this is a misuse of the rule. These cases properly belong in district court under condemnation proceedings with legal standards designed for this exact scenario. Thank you. I have no further remarks.
Thank you. Mr. Prescott.
Thank you, Chair. Just going to share my screen. And thank you, commissioners, for being attentive, participating, asking good questions, and ultimately helping resolve this. Before I get into my slides, I'll just respond to a couple legal principles that Mr. Willis just discussed. One, talking about preclusion. Well, first, let's back up. I'm confident you've reviewed the record in this case, the filings of the parties. I think you'll see that Walton provided you with pretty robust information, discussion, explanation, evidence. In review of what KPK has filed to date prior to this hearing, I think you'll find that it's incredibly light. So I would ask that you start there. As we discussed in our pre-hearing statement response, preclusion's not legally available here. There were many months of reduction from the Firecracker Unit 1 well that were not contemplated in a previous hearing. In addition, Walton was not a party, and therefore either form of preclusion, whether it's collateral estoppel or res judicata, the primary factor is not met, is only available if that party was a party to the prior proceeding. So that's just one example of the many red herrings that you're getting from KPK. Second, Mr. Willis described Walton's burden as heavy. Walton's burden is a preponderance of the evidence, the lowest of all of the burdens. It is a more likely than not burden. Two examples. Is it more likely than not that KPK's wells didn't have the best production of their lives decades after they were drilled? Is it more likely than not that KPK's workovers related to mechanical issues and tubing leaks resulted in little to no change in production? If it is more likely than not in both of those instances, KPK loses. Lastly, on the legal side here, we're like condemnation. It's major red herring. KPK has provided no evidence, A, that a district exists that could pursue condemnation, what the standard for condemnation is for a district. The statutes are pretty clear. Districts have very de minimis eminent domain powers. It still remains unclear that a district could even condemn an oil well. Just because one district filed one condemnation case and then settled it does not mean that districts have the power to condemn. We're going down rabbit hole after rabbit hole when KPK talks because their case does not support their defenses. Let's all take a step back and look at the timeline. Look at what happened. Walton did their research and filed the Rule 211 applications in December and January 25-26. On-site observations, the facility on file with the commission for these wells, the facility with a sign identifying these wells had been abandoned for 7, 8 years. I direct you back to Mr. DePorter's testimony and his declaration. This in the filings. The wells were observed to be inoperable for 7, 8, 13 years. These wells were not used or useful. Absolutely no possible way, based on on-site observations and Ms. Lencioni's economic analysis. Her analysis wasn't disputed. KPK's defense in this case is, well, starting in April, these wells started producing a lot because we did workovers. And let's run through that now. March 2026. These applications have been on file for 3 months, set to go to hearing in April and May. KPK seeks their first continuance. The hearing gets pushed to late June and then early July. With that delay, KPK files a Form 42 and works over the Graham well, a tubing leak. In May of 2026, we catch KPK changing production records for the Stonebreaker well in the fall of 2025. In June, KPK seeks another continuance. So now we're pushing the hearing out to August. In July, we get KPK's expert report stating all the wells were worked over, specifically using the term workover, in April, resulting in increased production. That is KPK's explanation for why these wells are still used and useful. August 2026, apparently KPK started reviewing everything Walton had filed and started changing its story. Here's what we've heard. There weren't Form 42s for 2 of the 3 wells because 2 of the wells didn't have workovers. They had work done. By workover, KPK means we went out and fixed a control box. Guess what, guys? That doesn't increase production. We went out and connected the bridle. Well, that just allows a well to pump. That also doesn't increase production. Walton states that April workovers can explain production, extensive production being reported now for February and March. So now KPK changes the story in the signed report of their expert. Oh, the work wasn't done in April. That report is wrong. It was actually done in January. Again, another explanation. Walton says, well, this facility that services all of these wells has been abandoned for 7 years. Oh, no, since 2022, we changed the valve and sent the oil and gas and water to a different facility. So the oil and water at that facility, we're just leaving it there. See where I'm getting at? Every argument Walton makes, KPK starts making new excuses and changing their story. KPK used delay tactics and didn't actually provide you with any proof in this case. For KPK to succeed, the commission must accept that workovers occurred in 2026 and resulted in the same or better production than the initial production from these wells decades ago. Despite that 2 of the 3 workovers were simple mechanical fixes. A well timer, the clock that turns the well on and off, and a line blockage. The third workover being a simple tubing leak. These are all common workover fixes that KPK conducts on a daily basis. Going back to the Frederick DeCono 211, every time we talked about a workover, KPK testified, oh, we did a tubing leak. Oh, we did a mechanical fix. In no case did it result in significantly more production. These wells, we see past workovers, Form 42s being filed, 25, 24, 23, 21. In no instance did we see a resultant increase in production. In every instance, either stayed the same or went down. Same with a refrac. Even if KPK came here and told you, oh, we refracted the well, that's why it produced more. Well, when the Stonebreaker was refracted back in 2005, it started producing less. Despite on-site observations from Mr. DePorter that the wells didn't operate during months where KPK expressly reported production to you. He's telling you, these wells are not pumping. They cannot pump. The bridle's detached. The polishing rod's detached. The electrical cord that needs to power the well is hanging over the edge cut. How can KPK report production, even 1 barrel of production, under these conditions? Well, they did for years. Despite the knowledge that KPK allocates field-wide production from an unknown number of wells feeding into this alleged facility 4 to these 3 wells now. Despite the fact that KPK can juice production simply by changing the allocation factor. Hey, we're going to change this well from 0.1 barrels a day to 3 barrels a day. Guess what? That well just increased 30x, which is essentially what we saw. KPK, despite many questions from me and from you, cannot explain their allocation calculation. They say there's the software that they use. They say that it requires inputs. We all asked how many wells are contributing to this volume. Couldn't answer that. Mr. Kaufman couldn't answer. Ms. Clark couldn't answer. No one at KPK can answer. Even though they're very certain that there is another facility servicing many, many, many wells, we don't know how many. We don't know when those have been worked over. We don't know when those have been tested. How can we trust this allocation methodology that KPK is telling us exists? And despite a 1-day test on oil during alleged flush production right after these workovers occurred to support these new mystery allocations, despite no actual evidence. For KPK to succeed, the commission must accept KPK's word versus third-party observations and commission records. KPK did not present an independent witness. KPK presented 3 self-serving witnesses that have been employed by KPK for many years, in Ms. Clark's case, her entire career, and in Mr. Mailer and Mr. Kaufman's case, many decades. On the other side of the coin, Walton presented Mr. DePorter, who himself has extensive industry experience and is simply a land manager on the property. He's just here to tell you what he sees. And Ms. Lanzioni, an independent petroleum engineer, no relation whatsoever to Walton. And then let's think about the actual evidence you saw. You heard a lot. You heard a lot of words from these self-serving witnesses. What did you see? You saw a workover rig, and Mr. DePorter testified, yeah, I saw a workover rig. Okay, so a workover occurred. That's not disputed. We also saw a document with handwritten test results. We don't know who did the tests, but we see some handwriting on a piece of paper. That's it. KPK could have easily proven its case if it had the evidence. KPK could have easily proven actual production are the numbers that it's reporting to you, by giving us some royalty statements. They need to pay their mineral owners. Mr. Mather couldn't even tell you that they have. They could have tested more. As Ms. Lencioni said, one random test in April after doing work isn't going to tell you what production is. She expected bi-weekly testing. KPK could have easily brought their little separator that goes in a trailer, as Mr. Kaufman explained, brought it out to these wells every week and said, see, look, it kept producing what these test results are. It could have actually given some evidence to support those test results. There's no commission filings at all supporting this change of facility or the work done on 2 of the 3 wells or anything at all supporting this allocation system except how Ms. Clark tried to explain it. And now we're going to look at KPK's reported production that actually refutes KPK's test results. Here's the firecracker production. As you see, KPK started reporting actual production this well in February of 2026. Their test said 1 barrel a day in April. In February, if you do the math, 48 barrels produced in 26 days, that's 1.8 barrels. That's almost twice as much as KPK's test says it was capable of producing. How do we get to that allocation? The allocation that KPK says applies can't possibly apply here. How can the well produce 1 barrel a day in April, but in April it was producing 1.8? Additionally, you heard what Mr. DePorter said. Here we see KPK reporting a bunch of production in 24, 25, 26. By a bunch, I mean 4 MCF, 7 MCF, 21 MCF. Oh, out of nowhere in February, 48 barrels. Mr. DePorter told you this well hasn't been operational, been able to operate, nor has it pumped outside of 1 day in April. So how is this reported production even possible based on on-site, in the field observation of this well and what it is and is not capable of doing? As discussed, these September, October, November production numbers for oil, 33 barrels, 36 barrels, 12 barrels. When Ms. Lencioni did a report in April, that was 0, 0, 0. KPK went back and increased those and never explained to you why or how. And again, what is this mystery allocation? The test showed 3 barrels a day. In February, it was allegedly producing 5 barrels a day, 140 barrels produced in 28 days. Gram production. This one's even better. In April, their tests show that it was producing 5 barrels a day. They reported to you 3.1 barrels a day. What? Again, the reporting is not reliable. It cannot be relied upon. And as explored yesterday, it is very clear that for KPK to operate the Gram 1 well, they had to complete an MIT. That's what the warning letter says. They have admitted they haven't completed an MIT for any of these wells. And I think the rules are clear that for these extended periods of shut-in, the wells becoming inactive, they're required to do an MIT. So KPK's case relies on this inflated production and the existence of this other facility being utilized. Again, KPK had every opportunity to give us actual evidence to support this. Royalty statements, weekly tests, we don't have that. Now, KPK, we're hearing today, again for the first time, how, why, and when an alternative facility is utilized to service these wells. KPK's filings with the ECMC indicate something completely different. An inspection at the firecracker facility found that that KPK had to calibrate gas metering equipment annually to comply with Rule 430D1. This was in September of 25. KPK responded in December of 25 that KPK will send a request to DCP to schedule gas meter calibration procedure. Results will be submitted to the ECMC. Why is KPK telling the commission that they're going to talk to DCP about calibrating the meter at the firecracker facility if KPK is no longer using the firecracker facility? Why is the ECMC sending inspectors to the firecracker facility if KPK is no longer using the firecracker facility? The ECMC and their staff doesn't even know what facility is being used for these wells. The public doesn't know what facility is being used for these wells. The sign for the firecracker facility still clearly indicates that it's servicing these wells. Now KPK, for the first time, is coming in and telling you, actually, we're sending this production elsewhere because we changed the valve in July of 2022 without telling you because of air emission issues. None of it makes sense. KPK has Form 44s on file with you that have not been modified, amended, or changed, saying that flow lines from all the wells in this area going into the separated firecracker facility. If KPK did modify the flow lines and infrastructure, one would think Mr. DePorter would have noticed, hearing today that they turned a valve. Maybe that's not true. But wouldn't KPK have to report this? Wouldn't the commission want to know and have to know? Shouldn't the public know? Why is this firecracker facility still in existence? Why is there oil in the tank? Why is there water in the tank? Why has it been left there, abandoned for, according to Mr. Kaufman, 4 years now? All three applications should be granted. The only reliable evidence shows none of the wells are capable of producing more than the nearby UPRR 43 Pan Am I-25 well, which the commission ordered to be plugged last year, which was no longer used or useful. The only reliable evidence shows the wells are and will continue to operate at a loss, with no ability to cover standard regulatory costs, closure costs, remediation costs, just general operating expenses. KPK has and continues to refuse to clean up a massive open oil spill. Mr. Kaufman couldn't really answer your questions about what testing has been done and what it shows. He says testing has been done. He couldn't confirm that the test came back and showed that the water or the soil was clean. On the other side of the coin, Mr. DePorter, who's there regularly, sees the sheen on top of the water. He sees the oil in this water. So when KPK tells you that, hey, we've cleaned it up, we're just waiting for you and your staff to approve it, how could that be true? There are pictures being taken of wildlife in that excavation. And then there's also the point that's been made multiple times. Pretty clear MITs were required for these wells that KPK openly says, no, we didn't do them. And big picture here, what's the point of all this? Well, affordable housing is one of them. Developers are being precluded from building homes, which are needed because of these old, uneconomic, and potentially unsafe wells in the field. And those wells are still in the field because KPK keeps trying to find ways to explain away all the issues with them. One asks that you find the 3 wells in their associated facility are no longer used or useful. That includes the firecracker tank battery. Find that closing the 3 wells in the firecracker tank battery, including remediation of the open excavation, is reasonable and necessary to protect and minimize adverse impacts to public health, safety, welfare, the environment, or wildlife resources. In order, the plugging, closure, and remediation be completed within 12 months. Again, thank you for your time and consideration.
Thank you very much. I want to start by asking Mr. Prescott if you can please send those slides to Mr. Smeltz so they can be included in the record.
Direct email to Mr. Smeltz would be the best.
Yes, please.
No problem at all.
Make sure and make sure it's also sent to the opposing party as well. But just so everybody has access to the slides that were relied upon during the testimony or during the closing statement. Before we go any further, commissioners, any final questions for the parties? Okay. Seeing no questions, at this point in time, I do think it's prudent to move to close the record to begin. So I will move.
Second.
Any comments or deliberations on that motion? Okay, all those in favor signify by saying aye.
Aye.
Okay, so the record is now closed. I do believe that it would be prudent to seek an executive session at this time. And so I do want to recognize AAG Davenport, who can provide us some detail on that.
Thank you, Commissioner Cross. Yes, the agenda does provide for an executive session to receive legal advice and analysis on issues presented in these 3 dockets. So that would be the purpose of the executive session as stated in the agenda and authorized by Colorado Revised Statutes. If you would like to go into executive session, we would need a motion to go into executive session for the purpose I just named.
So moved.
Second.
Okay. All those in favor of entering executive session signify by saying aye.
Aye.
Aye. Okay, that motion passes. So we will go into executive session. As Chair Robbins always tells everyone listening in, we will be going to a separate Zoom meeting. So the commissioners and AAG will be signing off from this Zoom meeting. I'm not sure how long we will be on this. And I don't want to make any promises, but I'm going to guess probably at least half an hour or so. And so we will return to this Zoom meeting at 11, we'll say 11:50. But I will make sure that should that time be later, that it's updated on the returning screen that's showing on here. But at such time, we will come back and proceed after the executive session. Wonderful. I did note that the screen there indicated 12 o'clock estimated return time. So we'll give a couple minutes here for Mr. Prescott as well as Mr. Schwartzengruber and Mr. Wells to return.
Commissioner Cross, this is Nick Schwartzengruber. I'm here. I just didn't visualize, so.
Okay. Perfect. All right, we have AAG Davenport back. So we have returned from executive session, so I believe we will call on AAG Davenport to read his script before we move to leave executive session.
Thank you, Commissioner Cross. Commissioners, members of the public, the commission is returning from executive session. That executive session, which was noted before the commission went into executive session, the purpose was to receive legal advice and analysis regarding issues presented in this docketed matter. The commission did not vote in that executive session, and it did not deliberate or otherwise reach any conclusions in that executive session. Commissioners and Commissioner Cross, we now need a motion to exit executive session.
So moved.
Second.
All those in favor of exiting executive session signify by saying aye.
Aye.
Okay, that passes. We have moved out of executive session. All right, as we begin here, I just want to double check with commissioners to see if they have any final questions or comments for the parties. Okay. Seeing none, next up on the pre-hearing order is for commissioner deliberations. And I wanted to open it up to commissioners to see if everyone's ready to deliberate now, if they would like some additional time. I think I, for one, would appreciate some additional time to kind of compile my notes and put something a little bit more clear and coherent together than my scribble that I have in my notebook right now. But I wanted to see what other commissioners were thinking as well. Commissioner Messner.
Yes, I suggest we return at 3:30.
Perfect. That works for me as well. I know Commissioner Oath has another working group meeting until 3, so that would provide some wiggle room after that as well. So if other commissioners are good with that, then I suggest we return to provide our deliberative comments at 3:30 today. Okay. AG Davenport, do we need a move to continue or just kind of just say we'll return at 3:30?
It's fine to say we'll return at 3:30.
I appreciate it. All right. To everyone listening in, we will see you back here in about 3.5 hours. I do want to make sure that we have AAG Davenport with us.
I am here.
Wonderful. And while I don't think it is necessary for them to be here for our deliberations, okay, I was going to say I do want to make sure that each party's attorneys are also present. And I know Mr. Prescott was just elevated. I just want to make sure that they are at least here.
I am present.
Perfect. Thank you. And is either Mr. Willis or Mr. Schwarzenegger here?
Yes, Rob Willis is here.
Perfect. All right, then we will begin. Welcome back, everyone. It is still August 20th, 2026, and this is a continuation of dockets number 251, 200-254, 251, 200-257, and 260-100-021. We have heard the testimony, cases in chief, rebuttal, cross-examinations, etc., of both parties, and we are now set for deliberations from commissioners. Do any commissioners wish to begin deliberations? I'm happy to start. No one's eager to jump in here. I will say that during the hearing on the 211 motion by Dacono and Frederick last summer, my deliberative comments were pretty lengthy. And I do aim to truncate those comments today, but I do note that many of my comments from that application were similar to today's. As many of the arguments and evidence presented in this hearing were similar to last year's 211 hearing. I'll address first an overview of Rule 211 as a foundational basis for my decision, and then discuss adherence to the rules, and finish with my evaluation of each prong of Rule 211. So for the rule background, as I noted during the Rule 211 hearing last year, in analyzing the rule, we must begin with the plain language of the legislation or the rule. The rule is based on prior COGCC Rule 208, which allowed the Commission to require wells to be plugged and abandoned if no longer used or useful. As with many of our rules, this regulation was updated in accordance with SB 19181 and added the ability to require plugging and abandoning if reasonable and necessary to protect or minimize adverse impacts to public health, safety, welfare, environment, and wildlife resources. Our regulations define used or useful as a well location or facility that is currently being used or has an identified future beneficial use, which may be indicated by, among other things, production trends for the well, plugging and abandonment, remediation and reclamation costs in relation to the well's gross revenue generation, failure to use or develop a facility, remaining economic viability, or other relevant evidence. I will get into each of those factors in my evaluation, but in the meantime, it's important to note that in statutory and regulatory interpretation, you have to give meaning to all the words in the rule. As with the previous hearing, KPK has argued that certain liabilities, such as remediation and plugging and abandonment, should not be considered in the viability of a well. That simply cannot be the case. However, the operator would like to characterize or account for liabilities, the rules are clear that remediation, reclamation, and plugging and abandonment costs must be taken into account in our evaluation under Rule 211. Another important point is the reasonable and necessary language when it comes to the protection of public health, safety, welfare, environment, and wildlife resources. While reasonable and necessary is not defined in our rules, the inclusion of reasonable and necessary, and particularly necessary, is critical to my evaluation in this decision making. While not enforceable or part of the rules, I do look to the statement of basis and purpose for guidance on this rule, as particularly given the limited application of this rule in the past. As explained in the statement of basis and purpose, the rule has been rarely used. And indeed, the commission does not intend for a hearing to occur at every instance of a well that is shut in or a corrective action that's required. Such a broad application is surely not what was intended and highlights the importance of the reasonable and necessary inclusion that I described above. We already have rules that provide requirements on safe operations, measures to protect public health, safety, welfare, environment, and wildlife resources, to reclaim sites, and regulatory steps for addressing remediation. Similarly, our rules provide for the ability to shut in wells as necessary for maintenance and repair operations. Therefore, it's clear that mandating plugging and abandonment pursuant to Rule 211A or facility location closure pursuant to 211B should be reserved for situations where our rules alone are insufficient to address the on-site situation that has led to the application. But more succinctly, where a requirement to plug and abandon or close is reasonable and necessary to protect or minimize adverse impacts. I do want to talk a little bit about adherence to the rules. As with our prior 211 hearing, a significant amount of testimony and argument concerned KPK's alleged failure to comply with ECMC regulations and alleged and improper reporting. These allegations include, but are not limited to, failure to conduct an MIT, failure to file Form 42s for workovers, failure to update signs, or update for Form 44 to show the connection to Facility 4. I acknowledge that KPK has repeatedly failed to comply with our commission rules. Indeed, during the 211 hearing last summer, it admitted it repeatedly failed to file requisite Form 27s as part of its remediation process, as is the case with the firecracker facility discussed in this matter. KPK also admitted last year that it has failed to conduct requisite mechanical integrity tests on many wells. Here, they did argue that they were not required to conduct MITs on these wells, and that the Form 42 was only required for the Graham number 1 well, as it was the only well that had a workover rig on site. There is no question that KPK has a history of failure to comply with commission rules, oftentimes unsympathetic admission of failure to adhere to rules. And such violations may have occurred at these sites too, and I hope our hardworking staff looks into the allegations made during this hearing. However, I will not address the validity of those allegations or KPK's responses today, as that is not the issue before us. Instead, I'll look at each prong of Rule 211, that is, whether the wells at issue are used or useful, or whether it is reasonable and necessary to plug and abandon the wells to protect or minimize adverse impacts to public health, safety, welfare, the environment, or wildlife resources. I'll first talk about used or useful. And again, my overview of the used or useful analysis remains the same as the prior Rule 211 hearing. The definition of used or useful means a well or location that is currently being used or has an identified future beneficial use, and provides the factors to consider in making that determination. While on its face, the or in used or useful suggests a currently producing well, regardless of production, satisfies the definition, such an outcome is illogical. Even if a minuscule amount of production was sufficient to avoid forced plugging and abandonment, operators could theoretically avoid plugging liabilities for years. Therefore, some ambiguity exists, and we must look to the statement of basis and purpose for clarity. In the statement of basis and purpose, use alone does not meet the standard. The 5 factors to evaluate are applicable to the combined phrase. As the statement of basis and purpose explicitly states, both components of the definition are important, and they are intended to be inclusive, not mutually exclusive. That is why the factors are described as a non-exclusive list factors that the Commission determined are relevant to identifying whether a well continues to be used or useful. It's clear that the factors apply to used just as they apply to useful. Thus, a used well may not be a useful well. A significant portion of this hearing was focused on the competing expert testimony between the parties regarding the valuations and economic viability of the wells in conjunction with the used or useful standard. I do have serious concerns about the validity of KPK's valuations. I found Ms. Lencioni's testimony about the decline curve credible, as was her testimony about the surprising jump in production after the work done on the wells. I also have concerns about the accuracy of the reporting done by KPK, especially considering Mr. Lewis Prescott's quote-unquote mystery allocation argument. With respect to the mystery allocation argument, I would note that what he showed is the test on the Graham #1 well resulted in a higher production than what was reported, while the test on the Stonebreaker well resulted in a comparably lower production than what was reported. So it was also unclear if those just kind of evened each other out or what may have been the case. Despite these concerns, I do not believe that the applicant has carried its burden here to show that the wells are not used or useful. As with the prior hearing, I do believe Ms. Lencioni did a good job highlighting uncertainty with KPK's costs, but I find validity in KPK utilizing its own operating costs. Unlike the financial assurance hearing, during which the Commission needs to assess third-party costs to plug and abandon or remediate, KPK's costs, although suspect, are appropriate as we seek to determine if the well is economic for KPK. And while KPK continues to argue that plugging and abandonment, remediation, or reclamation costs should not be considered because they're not what was described as recurring direct variable costs, despite the applicable rule explicitly stating otherwise, they did compare their valuations to the plugging and abandonment reclamation costs consistent with the financial assurance hearing. On the other side, much of the applicant's arguments focused on showing that the wells are not used or useful, focused on old information or questioning of reporting. Indeed, Ms. Lencioni did note that her valuation of each well was based on reporting data through January 2026, despite subsequent work being done by KPK to increase production. While the reporting is indeed suspect, I do not think the applicant met their burden to show that production is not occurring. So while I believe KPK's valuation is likely overstated, I think applicant's valuation is similarly understated, making a conclusion that the wells are not used or useful difficult, if not impossible. Certainly, given that it's applicant's burden of proof, I do not believe it is shown that the wells do not have the necessary value to be considered used or useful. Relatedly, I had concerns with the reliance of the applicant on Mr. DePorter's remediation costs. First, the remediation was for the facility, not the wells, and I'm not sure the even breakdown of costs between the 23 wells that went to the facility is appropriate. Even assuming that is appropriate, I do not believe we have the supporting information to justify Mr. DePorter's estimated costs. Instead, we have blanket statements that for regulatory compliance for remediation costs, as well as just a conclusion of the work costs, which was apparently based on a spreadsheet that was not disclosed and discussed during the hearing. One other thing with respect to valuation, I'll say that I did not take Mr. Mailer's testimony into account in my decision. During the prior 211 hearing, I criticized the use of the comparable transactions as a valuation method, and I did not find his testimony on the prior agreements convincing in this matter. I also want to quickly address the identified future beneficial use. Again, my reasoning here is similar to the prior 211 hearing. KPK again argued that they have a beneficial value in all of these wells because they can be refractured and there's potential for enhanced oil recovery and even carbon capture and sequestration. In my opinion, KPK has failed to show these are possible future beneficial uses. The statement of basis and purpose specifically states that an operator must present relevant evidence indicating identified future use. That simply was not done here. I recognize KPK engaged Netherlands Sewell to evaluate potential work, but that was done long ago, and it does not provide the requisite evidence to show that this future use is planned to occur or is likely to occur. There's no evidence to support that this is a real possibility. Mr. Kaufman testified previously that banks would loan them money to do refractures, but now what they're focused on spending their capital allocation on is remediation. So the other uses, enhanced oil recovery and CCUS are even more lacking. But KPK again testified, although sparingly with little detail, about potential grants, but there's no evidence that KPK can do this, or they can afford to do this, or has any plans to do so. Next, I'll move on to the reasonable and necessary to protect and minimize adverse impacts. I'll be succinct here. The applicant did not present any evidence that the wells at issue pose a direct threat to public health, safety, welfare, environment, or wildlife resources. Moreover, there was no evidence that a plugging and abandonment would be necessary to protect or minimize adverse impacts to public health, safety, welfare, environment, and wildlife resources. While I do think there are public health concerns with the firecracker facility, I think that the situation is, again, similar to the 211 hearing that we had before. That is, ECMC is already managing and overseeing the remediation of this site. And because of that, it is not necessary to protect or minimize adverse impacts. The closure of that site is not necessary to protect or minimize adverse impacts. We're already taking the requisite action on that. I do want to make a couple, specifically one final point. One of the things that came up during the hearing was Mr. DePorter talking about that he specifically went into the facility, opened up tanks to see how much was in the tanks, climbed on the equipment, etc. I just want to strongly state to all stakeholders listening in, do not do this. The work in and around these facilities and this equipment is dangerous. And although Mr. DePorter does have prior experience working in the industry, accidents happen. And without the proper equipment and other people around, it's not safe and not appropriate to climb on this, let alone the fact that he's not supposed to trespass onto that property anyway. So I do want to just quickly make sure that stakeholders know this should not occur in the future. But again, I wanted to try and be more succinct than I was during the previous 211 hearing, and I think that is the totality of my comments for now. Other commissioners with deliberative thoughts. Commissioner Messner.
Thanks for your thoughts, Commissioner Cross. We have some similarities and some disagreements, I think, but I think basically there are, it's not been an easy analysis, and I appreciate all of the information provided by each of the parties. I also would like to explain my approach to determining the outcome of the wells in question in this matter. I think it's important that you understand the different things that I'm looking at in making my determination. There's definitions that I utilized, including definitions of well, plugging and abandonment, remediation, reclamation, oil and gas facility, minimize adverse impacts, used or useful, and others. The primary rules, I believe, apply to this proceeding include Rule 503 G12B, where the relevant local government or surface owner may file an application to plug and abandon a well or close an oil and gas location pursuant to Rule 211. Such application by a relevant local government or surface owner will include a certification that the relevant local government or surface owner has conferred in good faith with the operator, a certification that the well has been low producing well for each year of the previous 3 years, and evidence demonstrating the well is either a threat to public health, safety, welfare, the environment, or wildlife resources, or no longer used and useful. Also utilize Rule 211, plugging and abandonment of wells and closure of oil and gas facilities and location, which Commissioner Cross has already shared the details with you. And then review the statement of basis and purpose as it was developed in the financial assurance rulemaking regarding Rule 211 for perspective. That starts at statement of basis and purpose on page 23, where it states a well or an oil and gas location or an oil and gas facility with or without associated wells is no longer used or useful if it has two core characteristics. First, that the well is not currently being used. And second, that the well does not have an identified future beneficial use. I think it's important to go on here where it states the commission recognizes there may be scenarios where a well may be repurposed for a use other than hydrocarbon production, such as an injection well, a carbon sequestration well, geothermal well, or geothermal co-production well. The commission determined that these repurposed uses are beneficial and intends to allow future beneficial uses to be considered for the useful determination. Yeah, and it goes on also to say that both of these components are of the definition are important and they're intended to be used inclusively and not mutually exclusive. First, the commission determined that production trends are highly relevant in determining whether a well continues to be used or useful. Production is the primary and often only source of revenue for the well. Therefore, declining production over time or zero production is a strong indicator that a well is no longer used or useful. Second, the commission determined that the ratio between a well's gross revenue and plugging, abandonment, remediation, and reclamation costs is an indicator of whether a well continues to be used or useful. All wells must be plugged and abandoned, reclaimed pursuant to the Act and Commission rules. Some wells must also be remediated to clean up contamination or spills and releases. Thus, when the cost of conducting these required activities exceeds the revenue actually generated by the well, it is a strong indicator that the well is no longer used or useful. The commission recognizes that it is important to review gross revenue over time. Accordingly, it intends to consider a relevant time frame that factors in the remaining production from a well, if any. The commission will also consider an operator's total number of wells and production from those wells over a recent time frame, likely the last 5 years. And finally, the commission will consider an annual average of the operator's gross revenue over a 5-year period. The commission would review the operator's gross revenue from the well in conjunction with the status of the operator's financial assurance for the well. Third, the commission identified an operator's failure to use or develop a facility as an indication that the well is no longer used and it may no longer be used or useful. In some cases, the commission encountered situations where an operator attains a permit or partially constructs a location or partially drills a well but does not complete the process so as to generate revenue from a completed well and is not using the facility. The situation would be an example of one which an operator fails to use or develop the facility, which indicates that the facility is no longer economic for the operator to complete or develop, and therefore is no longer used or useful. Fourth, the commission determined that remaining economic viability is a factor that may indicate that the used or usefulness of a well. The commission recognizes that many varying factors determine the economic viability of a well, including price uncertainty and cost variability. Accordingly, the commission will consider relevant financial evidence from the operator to help identify whether the well continues to be economically viable and ultimately used or useful. Finally, the commission recognizes that other factors not listed in the 100 series definition of used or useful may also be relevant in determining whether a well is used or useful pursuant to Rule 211. Accordingly, in some Part E of the definition, the commission included a catch-all for other relevant evidence, which the commission recognizes may vary on a case-by-case basis. The elements of the definition of used and useful are intended to be the criteria that the commission will weigh when determining whether a well and/or a location are no longer useful in a well or location closure hearing. The elements are also what the operator would be required to show as an affirmative defense in such a hearing. The commission will entertain arguments from an operator about why a well or location is indeed still used or useful based on the elements listed in the definition. So first, I'll indicate that I believe the applicant has met its burden of proof and that it is conferred in good faith with the operator and has certified that each of the subject wells has been low producing for each of the previous 3 years. As to the determination of whether it is a threat to public health, safety, welfare, the environment, or wildlife resources, or whether or not the wells are used or useful, my thoughts are as follows. Generally, my approach was to evaluate each well first to determine that it is being used. The clearest way to determine this is to see if the well is actually in operation and is producing oil and or gas. As indicated in the SBP, there are many reasons that a well may not be in operation, and for my analysis, I did not distinguish between any particular reason the well may not be in operation, but rather evaluated the wells based on testimony and evidence as to whether or not they were being used. While there is some question as to the accuracy of the production information provided, some changing testimony by KPK, which led to some reliability issues in their testimony regarding production timelines, and testimony provided by witnesses associated with the applicant additionally provided some circumstantial evidence that there may be some question as to whether or not these wells could be producing. I believe it is reasonable to determine, based on some level of production records, that each of the wells at issue are in fact used, even if the amount in which they are producing is at question. As indicated in the definition of used and useful, there are 5 criteria to evaluate the usefulness of subject wells. As I indicated in the SBP, the commission recognizes that the used or usefulness of each well is different, and in some cases may relate as much to the financial characteristics of the well's operator as actual production trends at the well. Accordingly, the commission identified a non-exclusive list of factors that it determined are relevant to identifying whether a well continues to be used or useful. Commissioner Cross has already shared the relevant items, and so I'll give some perspective on how I evaluated each of these items. For production trends of the well, I looked to the SBP, which states the commission determined that production trends are highly relevant in determining whether a well continues to be used or useful. Production is the primary and often only source of revenue from a well, therefore declining production over time or zero production is a strong indicator that a well is no longer used or useful. It's common knowledge that production declines over time, as all parties have indicated in this proceeding. It's also known that the wells in question are between 35 and 60 years old. So it is to be expected that the decline curve on these wells would be relatively steep, and production would be significantly lower than earlier in the well's life. It was testified to by KPK that work was completed at each of these wells prior to bringing them back into full production, though the timelines associated with when each of these actions took place seemed to be a moving target. The actions taken included downhole tubing repair on Gram 1, paraffin clog removed from a flow line on Stonebreaker, and a control box clock replaced on Firecracker 1. No recompletion or work was done on any of the wells that could potentially improve the reservoir. Historic workovers done on the wells and reported to ECMC via Form 42s did not result in any significant increase in production associated with the wells on which the work was completed. Single one-day tests were indicated by KPK to have been completed on each of the wells, but little documentation was provided on the details of the test. Testimony provided no additional clarity and no follow-up testing occurred to verify numbers. In addition, no gas testing occurred as part of the production testing. It seems unreasonable to find that the significant increase in production reported by KPK due to minor work done on equipment could create the level of production numbers provided in Ms. Clark's analysis based on historic production numbers were provided that show little to no increase associated with similar work done on similar or the same wells. I also struggled with the determination of allocation to these 3 wells without knowing how many other wells are contributing to the production facility and at what volumes. And while there may be some software that is being utilized, any software or formula utilized to determine allocation can only be as good as the data utilized, and the data utilized seems to be incomplete and unreasonable. I also found the inaccuracies associated with the production reporting of gas in relation to oil, even when the alleged production restarted, highlights the flaws in reporting and allocation formulas utilized. Finally, the production decline curve utilized by Ms. Clark was adequately shown by testimony by expert witness Ms. Lincioni to not take into account steep declines associated with recompletion activities and unnecessarily inflates the production trends and decline curve. For these reasons, I find Ms. Clark's report and testimony regarding production trends unreliable, and find Ms. Lincioni's report and testimony a more accurate and clear picture of the elements reasonable and necessary to determine production trends. It is important to note that even if a well is at its low end of the production trend, does not mean, in my opinion, that it is not useful. The second item I reviewed is the plugging and abandonment, remediation, and reclamation costs in relation to the well's gross revenue generation. The commission was clear in the statement of basis and purpose that all wells must be plugged, abandoned, and reclaimed pursuant to the Act and commission rules. Some wells must also be remediated to clean up contamination or spills and releases. Thus, when the cost of conducting these required activities exceeds the revenue actually generated by the well, it is a strong indicator that the well is no longer used or useful. It is also clear to me that all of the elements included in this part must be evaluated. That includes plugging and abandonment costs, remediation costs, and reclamation costs in relation to the well's gross revenue generation. So that's what I looked at as best I could and tried to evaluate. There were many other expenses that were argued during this proceeding as having bearing on determining whether the subject wells were useful. I do believe these expenses speak to the economic viability of the wells, so should be considered as well. So I included economic viability in my analysis under this section. There are 3 specific wells at question here and 2 associated facilities in addition to associated flow lines. Each of these can be expected to have specific plugging, abandonment, reclamation, and remediation expenses associated with them. Utilizing a generic company-wide formula for determining a potential expenses associated with these specific wells and facilities for the items indicated above, as well as any OPEX or CAPEX anticipated for ongoing operations, seems unreasonably broad and inaccurate to meet the expectation of determining the economic viability associated with the determination of usefulness. When asked directly whether site-specific costs were analyzed, Ms. Clark indicated that they were not. I saw no evidence of any expenses associated with either production facility, which at times have been utilized by these 3 wells. Other elements that are a necessary part of evaluating the usefulness of a well as per the rules and SBP include financial assurance and regulatory expenses. Demonstrated costs associated with these wells have previously been analyzed and determined not reasonable by this commission in both a previous 211 hearing and a financial assurance hearing. No further information was provided on demonstrated costs in this hearing to change this opinion. So the plugging, abandonment, and reclamation numbers to be utilized would be the default amount of $30,000 per well and $100,000 per location. As to the regulatory expenses, it is clear to this commissioner, specifically on the Stonebreaker well, which was out of production for at least 23 months, and the Graham 1 well, which is out of production for at least 22 months, based on KPK's provided production reports, would have deemed these wells inactive at 12 months and at 18 months would have required actions associated with Rule 434C that include the option to plug and abandon the wells, provide single well financial assurance for the wells, or designate each of these wells on an out-of-service well list, none of which occurred. In light of this, each of the wells should have had an MIT performed on it before putting it back into production, or it could be considered a threat to public health, safety, welfare, the environment, and wildlife resources. The expense of these MITs should be included in the site-specific analysis. So for these reasons, I find Ms. Clark's economic analysis to be unreliable and find Ms. Lencioni's financial analysis to have developed a more realistic and clearer picture into the financial viability of each of the wells at question. I also looked at facilities, as there was a couple contemplated in these proceedings. The statement of basis and purpose states the commission identified an operator's failure to use or develop a facility as an indication that the well is no longer used and may no longer be used or useful. The firecracker production facility, based on testimony by Mr. Kaufman, has not been utilized since 2022. It has not been upgraded or improved since then to allow it to be utilized. Currently, any production is being routed to the location for production facility, but the number of wells and amount of production from wells associated with it is nebulous. In addition, the firecracker production unit has an unremedied pit associated with it, which creates some concern associated with impacts to public health, safety, welfare, the environment, and wildlife resources. And finally, I looked at other relevant evidence to determine usefulness and beneficial use. Items brought forward included fair market value, carbon capture and sequestration, deep geothermal, recompletions, and enhanced oil recovery. Based on the fact that this is the same testimony given at a previous 211 hearing by the same operator, which was deemed unreasonable by this commission, I did not see any additional information provided that would change the previous determination on these items. I also evaluated the preclusion argument and found that this is a unique applicant who provided unique testimony and evidence in a unique circumstance, so do not believe that this applies to these proceedings. So in conclusion, I find, based on testimony and evidence in the record and my deliberative thoughts aforementioned, that the three wells in question, the Graham 1, the Stonebreaker, and the Firecracker 1, are all used, and each of the wells in question are not useful. And for the Graham 1 and Stonebreaker and the Firecracker production facility, there are concerns. I have concerns regarding the impacts to public health, safety, welfare, the environment, and wildlife resources that haven't been alleviated by any staff efforts at this point. So I believe the applicant has met their burden of proof to seek the relief requested and would be in favor of granting that.
Thank you. Commissioner Oath.
Thanks. I guess I'll start by just noting that we have a situation where we have an application that was filed with evidence pertaining to three wells, and in response, KPK reprioritized maintenance work on them. And while KPK testified that they have an ongoing list of wells that need work, which I don't doubt, they have also testified that not a single other well that produces into this facility number 4. And again, KPK doesn't seem to even know how many wells produce into that facility, but testified that it is apparently dozens. And none of these other wells received any maintenance or workovers during this time. And so I find the fact that only these three wells having received any attention subsequent to the filing of the application suspicious, and also potentially a direct attempt to manipulate the situation. With respect to the Graham 1 well, there was evidence that a workover occurred in April 2026. We saw photos of the workover rig as well as testimony from Walton that they observed the rig, as well as filing of proper documentation with ECMC that this work was occurring. So I think it is clear that a workover did occur at this time. However, the testimony was that the work that occurred was to repair a tubing leak. I find the testimony from KPK that this type of work resulted in the supposed increase troubling. Ms. Clark testified that there was an overall increase in volume observed at the production facility. However, when I consider that testimony and its lack of detail, along with all of the times that various KPK witnesses have been unable to provide details about how many wells produced to the production facility, how the calculations are conducted, I find it unbelievable that the repair of a tubing leak could result in such an increase in production. I find KPK's testimony lacks specifics and details to such a degree that I find they either have no grasp of their basic business operations, such that their testimony lacks credibility, or the testimony is intentionally obfuscating. With respect to the Stonebreaker well, I would say the general statements that I made above carry over into my assessment of this well. There are several additional things specific to this well that I find also contribute to finding KPK's testimony to be not believable. That includes the fact that this well was refracted in 2005, and that did not result in a substantial increase in production. That there was no significant downhole work completed. This time it was merely to address a paraffin blockage. The modification by KPK of the production data in 2025, which was never explained, and the disconnect in the oil and gas ratio. With respect to the firecracker well, similarly, the general statements made above carry over into my assessment of this well. Also, additional things specific to this well that I will highlight include the activity that KPK claims was done that explains a sudden increase in production was the repair of a clock in a control box. KPK did not provide any evidence that I would find compelling to convince me that this type of repair could possibly result in the increase in production that they allege. And I want to be clear to KPK, the outcome of the 2025 hearing with respect to this well did not mean that the commission made an affirmative finding that the well is used and useful. Rather, it means that a majority of the commission did not find that the burden had been met based on the evidence presented at that time that the well was not useful. That is very different, and I hope that KPK does not try to recycle this argument in future 211 proceedings. A couple other things I will highlight with respect to all of the wells. I would note that there was, a major argument in this case from Walton was about the lack of change to the volumes in the tanks at the firecracker tank battery. And frankly, the fact that KPK did not provide information about where these 3 subject wells were producing to prior to oral testimony in response to repeated questions by commissioners, resulting in a situation where there has not really been any ability to verify production volume changes overall, and the fact that KPK has not represented to ECMC that there has been a change to the production location, and there's not been a change to the signage on site. These all contribute to my finding KPK's arguments and testimony regarding production to lack credibility. Also, the evidence presented by Walton's witness regarding the status of the wells with equipment not being attached and no pumping occurring further contributes to my inability to find KPK's arguments that production increased believable. And the evidence presented showing that the test numbers that were the basis for developing the new production rates in many cases did not match the reported volumes. This also contributes to my assessment of credibility. So in conclusion, I find that the applicant has met their burden to demonstrate that the 3 wells at issue are not useful under the criteria in our rules.
Thank you. Commissioner Ackerman.
Thanks, Mr. Chair, and thanks to my fellow commissioners. I would agree with Commissioner Messner. This is a particularly difficult issue to 11 hearings in general, and I think the testimony we heard today so far demonstrates why there is a level of discernment on our part, as well as a level of gray, as Commissioner Cross has said. And as my fellow commissioners stated, I want to state that I agree that the intent of Rule 211 is intended to be used rarely. It's very clearly stated in the basis and purpose statement that we have rarely used it in the past, and we continue to only use it in rare instances when doing so is necessary to protect public health, safety, welfare, the environment, and wildlife resources. Well closures under Rule 211 is intentionally a self-imposed very high bar. And I interpret this regulation being used rarely to mean that the Commission does not use the authority of 211 lightly, as I stated in the previous 211 hearing, but will use it in circumstances where all other reasonable avenues have been exhausted and unsuccessful, including but not limited to enforcement efforts, and then it therefore becomes necessary to use it to protect public health, safety, welfare, the environment, and wildlife resources. So for me, it comes down to whether the applicant in this matter has clearly met the burden of proof establishing that these wells must be closed. to protect public health, safety, welfare, the environment, or wildlife resources, or that they are no longer used or useful under our definition. And also that such closure would fall within the spirit of the applicable statement of basis and purpose that I just described. And I just want to be clear that that's the lens that I'm viewing the evidence presented in this application in. We've established clearly the used or useful standard. I won't go through that again. I also had some notes on Commissioner Oath's comment and agree with it that the previous order did not find all wells that were not ordered to be closed to be used and useful. It simply did not specifically find those wells proven to not be used and useful at that time, and agree with Commissioner Oath that this is not a legitimate argument. As far as production trends, as set forth by the testimony and basis and purpose of my fellow commissioners, we saw at the previous hearing too that this point is very hard to ascertain, especially with wells that have been mostly shut in non-producers for an ongoing period of time, particularly since the wells in question are now reported to be producing since the application was submitted. But real data associated with the production of those wells is very limited due to the questionable practice of 1 3-hour mobile separator test per well that then results in at least semi-permanent per well allocation calculations based on total gathering facility intake. It's a very, very tough mechanism and a tough way to monitor your business. Production data used by the applicant understandably used data from previous years to allege that the wells in question were not used or useful. And much of that time, these wells, they were shut in and they weren't producing, or they were producing very little, very sporadically. And so because they were shut in, it certainly may be reasonably argued that they were not being used. It's not reasonable, however, to assume that production reported from mostly or entirely shut-in wells is indicative of their actual production potential when they are operating properly. And as I mentioned, conversely, an autonomous 3-hour test used to establish well allocations as measured at the larger collection facility in perpetuity is absolutely far from the best business practice. And for these reasons, I generally think, as Commissioner Cross stated, that the applicant report, while I also found it reliable, may have hit on the very low end of future potential production. For many of the same reasons explained by my fellow commissioners, I also find it incredibly difficult to believe that the simple repairs made at each well have resulted in the significant production numbers reported since that time. I also have concerns on various fronts about the type of potential obfuscation discussed by Commissioner Oath. Here's my trouble, though. The burden here is upon the applicant. And yes, while the operator needs to defend its numbers, the burden's upon the applicant, and I do not find the applicant met its burden to establish a credible lack of production, but rather just alleged an alleged fraud, and asked for us to draw such conclusions absent any hard evidence. I also don't find that the applicant established a clear misreporting of numbers by any evidence, as it implied during its testimony. As far as failure to use, these wells' historic data of disrepair and very sporadic allocated production do provide unquestionably that these wells meet the definition of low producing wells over the past 3 years. The numbers also provide a strong argument that there's been a failure to use these wells all the way up through Q2 of 2026. So to me, the questions are then, does that render these wells also never useful? And does a failure to use the wells remain in place today? So as far as not useful, it's a high standard. Rule 2, this is from Order 1404 from the previous 211 hearing. Rule 211 places a heavy burden upon the applicant. Under the used or useful criteria, it's not sufficient to demonstrate that an operator is not using a well. It must also be demonstrated that a specific well is not useful. A well that is not being used is a well that is not producing oil and gas. However, not all unused wells are also not useful. The statement of basis and purpose from the financial assurance rulemaking on page 23 states a well may be temporarily shut in for a wide variety of reasons, including economic considerations and pipeline capacity. Therefore, even an unused well must also not be useful to meet the used or useful standard as set forth by Commissioner Messner in his testimony. So the question is it used now? Allegedly, yes. Numbers are being reported so long as the wells are currently producing. They are by definition being used. And if they're producing at the numbers that are being reported, they are useful. Current allocations remain there and remain ongoing at a standard decline curve. I certainly think it can be argued that the wells could be expected to continue to produce similar to other stripper type well situations, provided the well equipment remains in operable condition. It's difficult to make this finding for me because of the historic practices of KPK and because of the many egregious issues that KPK has on a number of their facilities. Nonetheless, once again, the burden is upon the applicant, and I don't find that the applicant met the burden of proof here. As far as economic viability, I did want to make just a couple of notes here prior to the meat of the testimony here. I certainly don't think there's been sufficient demonstration of future value in enhanced oil recovery or underground carbon storage. And to be clear, I'm not making a value judgment on those opportunities don't or won't exist. I'm simply stating that we're nowhere near sufficiently demonstrated intent or evidence on either of these issues for the wells in question to substantiate it as some criteria for economic viability. That was addressed in detail in Order 1404, and I remain of the same mind that I was previously. Also, we continue to talk about the real estate transactions associated with these types of issues, which I think is a driving factor from what I can gather from the arguments on behalf of the applicant. On one hand, the potential holdout revenue to be made from a land use buyout transaction, whether or not I find that to be an appropriate business practice, is certainly not a basis for evaluation of future economic viability under our rules. And I therefore discount arguments that there is revenue to be made associated with that practice. But on the other hand, a real estate developer's desire and intent to develop on and around land, as has been clearly stated in this and previous hearings, that's currently legally held by an oil and gas lease, and as an impetus for moving forward with this type of closure, to me also has no basis in ECMC regulation to necessitate well closures. We've stated a number of times the basis for financial assurance from the rulemaking and gross revenue and end of life. The point there that I wanted to make is that we are required to consider an operator's entire operation and gross revenue in considering this aspect. And to me, the operator's economy of scale argument holds enough water, given the evidence provided in this usage, as a small portion of a larger portfolio of low-producing wells. And so these wells, once again, if they remain operable and at reported production levels since repairs, demonstrate sufficient economic viability. As far as cost versus revenue, again, in my opinion, when operating at the latest production levels as currently reported since the repairs, I'll call them repairs because I don't think they meet the general industry terminology to be considered workovers. The wells do add some value, be it minimal, they add some value to field production. Another point that came up was that a great percentage of the Graham number 1 well is now being returned to investor. And I don't find that to be a compelling disqualifying point either. The regulation requires us to examine cost versus revenue potential, not ultimately how a company chooses to use the revenue derived from its production. We had a number of allegations that those numbers are suspect and not accurate that were reported by KPK. I've got to say, at face value, I agree with that take. I think it's reasonable to believe that they're suspect and not accurate. But again, other than drawing conclusions based on a situational observation, I did not see a preponderance of the evidence demonstrating that the reported numbers are indeed fraudulent. We heard some eyewitness testimony that those wells have historically reported some production while not being historically mechanically operable. And so I certainly can foresee that possibility as a weakness in a system that takes a one-time or rare periodic wellhead measurement and then allocates a percentage of the tank battery total to that well in perpetuity. A very difficult business practice, as I've stated before. Those 2 points concern me. And given this history and the new active and presumably now ongoing production in the wells, if these wells are allowed to remain open, I certainly would recommend that the operator install individual metering devices at each of these 3 wells to definitively demonstrate actual well production going forward, and should they find themselves in a similar situation in the future, to do the same. As far as other evidence, we heard about MIT issues, along with a number of other alleged potential violations. Financial assurance, remediation, specifically were identified. These are all real violations, and they're violations that our staff are working on. In Order 1404, we stated the Commission recognized that the applicant identified KPK failures to conduct mechanical integrity tests at the identified wells. But the failure to conduct an MIT, while a serious issue, and I would extrapolate this to the other topics I mentioned, still does not demonstrate that any identified well must be plugged and abandoned to protect public health, safety, welfare of the environment, or wildlife resources. I also just wanted to make some general points on some issues of concern, and my first is the initial workover message substantiating the increase in production. It was misleading at best. Workover, as it relates to oil and gas development in general, is understood to mean a major maintenance or repair operation on an existing oil or gas well to restore or to prolong or to increase its production. Most often involves pulling out the existing downhole production tubing and equipment to repair damaged components and altering the well structure to reach or improve hydrocarbon reservoirs. Unlike routine well servicing, like minor wireline adjustments and other items of the like, a workover is an invasive, complex procedure that requires a specialized workover rig, a mobile rig equipped with a derrick and drawworks to pull and handle heavy loads and tubing. So to me, the use of the term workover prior to the hearings, particularly to describe what happened to other knowledgeable industry professionals and industry attorneys, is at best misleading. And I found that lack of full disclosure until being directly examined at the hearing to be, frankly, particularly egregious. That also causes me concerns. In fact, as I've expressed before, I have many concerns with the KPK approach to their wells in general. It's very well documented that this commission has expressed a number of concerns with their general field practices, including MIT's financial insurance and remediation. These are all very important issues that, again, our staff continues to work on, but I don't find them to be a case for invoking 211 closures. KPK facilities are often left in disrepair for an extended period of time, and I think that this is probably the primary cause of most of the issues that we see this operator have. I certainly continue to urge this operator to clean up their practices if they continue to do business in Colorado, and to promptly address issues that arise, and to actively seek out to improve their social license. So while these matters are significant and are the subject of ongoing concern by me and certainly ongoing current actions by staff in this commission, a closure order is indeed a very significant request for relief. And my position is that ECMC must continue to work within all other existing processes to ensure compliance on all fronts by this operator. But the evidence presented isn't justification for such closures, as the arguments do not substantially satisfy the high burden of proof set forth under the purposefully narrow criteria and intended use of Rule 211, triggering the Commission's standard of exercising its discretion only in rare instances where doing so is necessary. I guess finally what I'd say is that my advice to this operator is properly clean up and use your wells and facilities, or properly close them. Don't wait for future 211 applications for closure to take place. And finally, my request for staff would be to ask staff to examine closely the numbers that have been provided by KPK as part of these hearings, to determine what's necessary from a staff perspective to substantiate that this is indeed the ongoing production that should be properly reported from each of these wells. Should those numbers change, I do find that that's cause to re-examine this issue. But again, I don't feel that the applicant met its burden of proof to substantiate that those numbers were fraudulent, which is the basis of the primary basis of my decision. Thanks, Mr. Chair.
Thank you. All right. Well, it appears we may be a little stuck here. I think it's probably appropriate, and Mr. Smeltz, I will call you up here. I think it may be appropriate to at least try a motion to see if we will be stuck on a 2-2 here, and maybe do a roll call on such a motion. But I first want to make sure no other commissioners have additional comments. Okay. If that's Commissioner.
I do want to make one comment. One of the things that Commissioner Ackerman said in his deliberative comments was around encouraging KPK to install meters at individual well sites that may be subject to future 211 hearings. I concur with that, very much so. So I wanted to make that comment.
Thank you for that. And I agree. You know, even the federal government now does allow commingling at facilities of their minerals, but there are very easy and very effective ways of managing that. And so I do encourage them to look at those methods to make sure that we don't run into this problem again. Again, maybe we'll just test this out to see where we are, but given no further comments, I would move to deny the application, and I'll say each application as presented by the applicant.
I will second.
Okay. Motion and a second. Do we have discussion on that motion? Okay. Then Mr. Smeltz, I will turn it to you for a roll call vote on that.
All right. Commissioner Ackerman,
Yes.
Commissioner Cross,
Yes.
Commissioner Mesner,
No.
Commissioner Oath.
No.
Okay.
The vote is 2-2, Commissioner Chair.
Okay. Thank you. So maybe I will call on AAG Davenport to help us out here and figure out what the best way forward will be given the predicament that we're in.
Well, I guess initially, Commissioner Cross, the motion that was just voted on, a tied vote, is effectively a denial on the motion, meaning that you need a majority of the present commissioners to approve a vote. So here today, that would be 3. So there's no action taken currently on any of the applications. My view of your options at this point are to potentially have further deliberations and see if there is a motion that this commission could get to 3 positive votes on. Barring that, second option could be potentially to continue deliberations to a future hearing date where either commissioners have a chance to think through things a bit more and maybe present other motions, or even wait until you have a full 5-member commission that would, of course, require our absent chairman to get up to speed, listen to all of the hearing, and be prepared to vote or make a motion there. I think those are your options.
Commissioner Ackerman.
Thanks. And I know other commissioners also have a suggestion, so I'll just throw mine out there. And I think I think I made pretty clear that my decision puts a lot of weight on trying to ascertain what the actual production numbers are from these wells. I think that, as a matter of fact, myself personally, my decision hinges upon those numbers. I mean, I would throw out an idea to continue this hearing and instruct staff to do some investigation and see if they can more closely ascertain for us the validity of those numbers, or where those numbers are.
Thank you. Commissioner Messner, I think I saw your hand next.
I think it's certainly worth taking a look, Commissioner Ackerman. I think I'll just make one attempt at an argument here, and I'm struggling a little bit with the utilization of the statement of basis and purpose as the primary reason for making a determination on the outcome of this particular application. I think that having been involved in the rulemaking that carried forward that element of being rarely utilized, did not intend for it to trump all of the other elements that are associated with the rulemaking and the determination of, what constitutes a Rule 211 hearing. And I'm concerned that the utilization of that one sentence in the statement of basis and purpose to trump all the other elements that we spent a lot of time on during the financial assurance rulemaking, and there was significant amount of stakeholder comments associated with it during the financial assurance rulemaking, including significant comments brought forth by service owners and local governments, that having those lines trump all that other work, I do not think was the intent of the discussions that we had during the financial assurance rulemaking associated with Rule 211 and the hearing style that is in front of us right now. In fact, the conversations that were had there were in fact an attempt to address a significant concern that surface owners and local governments had with things that were happening within their jurisdictions that were not previously able to be addressed, and in an attempt to try to find a solution to ongoing problems that have been historic and current problems within local government and landowner jurisdictions. And so while I acknowledge that we carried forward that language, that was historic language that occurred way before the mission change rulemaking even, I do not think that carrying it forward, even in the financial assurance rulemaking, was designed for it to trump all other elements that were incorporated in the used or useful section of that rulemaking. So just my perspective on that for you all.
Commissioner Oates.
Well, I don't know that I have a response to Commissioner Messner's argument. I think I had just had my hand up in the at the same time. And had a thought. I think I like Commissioner Ackerman's idea better. I was thinking, is there other ways to get at more information to test the production numbers that were alleged or provided? I don't know if there is a way for staff to look at that. I don't know if we would be able to require that meters be installed and continue this for a number of months and get that information. But that was why I had raised my hand.
Thank you for that. And I'll just say I like the idea of trying to get some kind of verification or some kind of investigation done by staff. As Commissioner Ackerman said, I think that I do find it very relevant. And for me, this matter is particularly difficult because, to Commissioner Messner's point, it's not that it's just supposed to be used and sparingly. To me, it's more so an issue of, we have a landowner here that wants to plug in abandoned wells so they can move forward with something else they want to do, but they don't want to have those wells nearby. And while I appreciate that, I also have concerns with, while the facility has some public health safety concerns, I don't necessarily see those same issues with the wells themselves. There's always going to be at least some posing of a threat because of a well being in existence. We do know that KPK has had numerous wells that have had remediation issues in the past. And so there's always that threat as well. But part of my concern when it comes to the protection aspect is that I didn't see anything from the applicant that says these wells themselves pose a threat to public health, safety, welfare, environment, and wildlife resources. And so for me, it really does go on the used or useful. And while I don't buy into KPK's economic valuation of the wells, as I said before, I think that we're kind of seeing maybe the very low end before work was done when it comes to applicants. And so that kind of puts the number somewhere in the middle. Because that number is somewhere in the middle, I don't know if it's just above that low end that applicant proposed, or if it's literally in the middle of I'm trying to pull up, I think it was a net present value, for example, of the Stonebreaker being described as the present value being $135,000 and a 20-year gross present value of 1.4 million. So if indeed it was 1.4 million, it would be more than sufficient to cover the plugging and abandonment and reclamation cost described in our financial assurance hearing with respect to KPK. But if it's on the lower end, that might not be enough. And so given that we don't have anything specific, we have a lot of questions. I like the idea of trying to get more information from it. I do recognize that would likely entail opening the record back up to get additional information, whether it be from staff or from the operator doing additional tests to us in the future. And so I do know that raises some concerns, and we'll probably want to talk to the parties about that as well. But Commissioner Messner, I completely understand your point. And for me, it's not the fact that this is a focus on, it's only supposed to be rarely used. For me, it's more of a focus of, while understanding that local governments and landowners want to have a say and should have a say in what's happening here, there are still contractual agreements in place. And I don't think it's necessarily our place to override contractual agreements just because somebody wants to plug and abandon a well so they can expedite development of housing on that land. Commissioner, if that's how you raise your hand.
I did, but I withdraw it.
Commissioner Ackerman.
Thanks, Mr. Chair. And I think you stated mostly what I was going to say, and I wanted to respond. Well, agree with Commissioner Messner's comment. I don't think that the rarely used provision in the statements of basis and purpose supersedes other items. I think that's exactly correct. It certainly didn't in my analysis of the facts here. And when it comes right down to it, I as I mentioned, I find those numbers suspect. I think that I'd like to personally believe that those numbers are not the accurate numbers that are being produced from these wells at this point. That said, I'm working purely from a burden of proof under the preponderance of the evidence capacity that we, as you stated, Commissioner Cross, we don't know what those numbers are at this point. I do think that we have, some range going on here. The low end of which would likely find them not to be useful, the high end of which would likely to find them to be useful. I just don't feel like the applicant met its burden of proof to accurately substantiate to the extent that it can what those numbers are, or even if those numbers aren't accurate, what those numbers would have to be in order to make the wells useful. And so I just wanted to clarify that I did not use that basis and purpose statement as a superseding point over my analysis.
Thank you. Commissioner Messner.
Thanks for that, and appreciate the perspectives of both of you. So I'll make another argument based on the numbers. This is my opinion. I think there's been enough questions raised by every commissioner here associated with the most recent and elevated production numbers that have been provided by the applicant. However, there's historic production numbers that have been provided by the applicant for many years, and been reported to ECMC as fact. Those production numbers seem more reasonable than the most recent production numbers that have been provided. I think it's also suspect that the production numbers provided after this application has been submitted show, at least in my opinion, unrealistic and kind of fantastical increases in production after minimal work done on the wells. And in fact, Ms. Lincione's analysis and report utilized KPK's production numbers. It's not her fault that the production numbers that the applicant or the operator chose to shut in their wells for a significant amount of time and only produce their wells periodically. That's the production numbers that they reported, and so that's the numbers that Ms. Lincione utilized. And so if you're looking at the most factual numbers, it's going to be the numbers that Ms. Lincione utilized in her analysis to determine production trends, because that is what was reported by the operator. So relying only on production numbers that occurred in the last couple of months versus utilizing what the operator has been, how the operator has been utilizing these wells over decades and reporting numbers to ECMC on, seems like the most factually accurate report to utilize in determining production trends. That's why I was arguing that Ms. Lincione is the most credible, had the most credible utilization of the production numbers, because she used the actual numbers. And so I hear folks saying that maybe unrealistically low, but I would argue that in fact they're not. That is how the operator has been utilizing these wells, and she utilized the numbers that was provided to ECMC by the operator, so they are in fact factual numbers on these particular wells. And so I throw that out there as another thought to my other commissioners.
And thank you for that. And I will say I agree that her testimony and her presentation was far more credible than Ms. Clark's. And I think one of the areas where I struggle is I don't want to step into an operator's business decision. And so while they haven't used the well or wells often, as you mentioned, one was shut in for 22 months, another was shut in for 23 months. It's not really my place at this point to criticize their business practices or their business decisions. And I really think where I have the problem is not that I find Ms. Lincione not credible. In fact, quite the opposite. I think where I have the problem is she's basing it on numbers where production really has been almost nil. And so if there is an increase in production, it's going to be higher than what she's showing. And so if this were a case of it's currently shut in, and we dealt with that a lot in the last 211 hearing, where many of these wells were shut in because they were required under the 901A order to be shut in. The used aspect of it was not really the issue, is are these useful even though they've been required to be shut in? But here, as they've gone from shut in to now producing, if they are producing, and maybe not even to the level that KPK is claiming, then is that enough to meet the useful standard? And so I completely agree that her testimony and her report is far more credible. But and as you were talking, I also pulled up the Stonebreaker production numbers that we have on our website. And you know, I think one of the interesting things with it is obviously you have a lot of zeros for the months that it was shut in. But even if you look back, there are times where, you know, they're producing 6, 12, 13, 15 barrels of oil a month. Um, and the gas as well. I think particularly for the Stonebreaker, what was surprising to me is even looking quite a way back, you're only seeing not numbers in the hundreds, except for maybe one or two, and all of a sudden now they're getting 1,000 cubic feet of gas. And so that those jumps were particularly jarring to me. The oil was also jarring, but at the same time, I did see oil production that, you know, in that 3 barrels a day is not implausible. And so that's where I'm really stuck, is that while I do think that her testimony and her decline curve is far more credible, we still, I have a hard time not taking into account that we are seeing production numbers. And part of the testimony that came in is if you look at the facility overall, there was corresponding increases. And if that is indeed true, then there is some kind of increased production by bringing these wells back online. I'm not 100% sure what that is. And so while I do think Ms. Lencioni was far more credible, I still have to give some kind of credence to the production that is occurring, but I don't really know where to put that at this point in time. Do we have other thoughts or comments? All right, given that AAG Davenport, I may call on you again. We seem to have an indication that we would like to see staff maybe do some investigation of this. Is it appropriate to continue until such investigation can occur? Or what's the proper method of having that kind of instruction moving forward? And Commissioner Oath, I see you raised your hand.
Yeah, can I just, sorry, before you answer that, AG, I'm sorry to interrupt. I think from my perspective, I'm not sure I want to place the burden on our staff to do this. So would welcome thoughts around how do we get more information around production numbers? Maybe that includes staff, but would also say I would consider further information from the parties as well, including future monitoring that would occur, or looking at numbers from facility number 4 now that we know that that's where these wells are producing to, et cetera.
Thank you for that, Commissioner Oath. Commissioner Ackerman.
Thank you, Commissioner Oath. And I would add to that I would also, and maybe even preferably, accept an impartial third-party analysis.
I would agree with that. I hate putting the burden on staff, especially as they're already doing a lot of other work. But I wanted to see if it makes sense to have some kind of analysis done for that. If it's possible to have the parties go back and provide additional information, conduct additional testing, or what might be the appropriate path forward.
Is it, Commissioner Cross, I apologize. It is appropriate for me to give thoughts at this point?
Yes.
Okay, thank you. So the primary thought that occurs to me is that continuing this matter to a date certain at this point might be difficult. I don't know how long additional investigation may take, or obtaining additional information regarding production may take. So my initial thought is to continue this matter to a date to be determined through conversations with the hearing officer assigned to these matters. by the parties. My understanding from this discussion is the commission is looking for additional information regarding production from the 3 subject wells. I don't know if you have more specific instruction about the type of information you're looking for, other than just additional information regarding production. But given that, I think returning this to the hearing officer makes sense to work through the details of what additional information the parties wish to present or can present, how long that may take to prepare for the commission, also recognizing your desire to have something from staff, not as a party, because they are not a party to this matter, but as your staff presenting information pursuant to your questions. It may take some time for staff to work things up to prepare for the commission. So my suggestion would be to continue this matter to a date determined by the parties and by staff and by the hearing officer when appropriate, to provide additional detail, if you have any, on what information you're looking for, and then leave it to the parties, to the hearing officer, and to staff to determine when it's appropriate to return to you with the information you're requesting.
Commissioner Ackerman.
Thank you, and thank you for that, Councilor Davenport. And I just wanted to clarify, in case I didn't make completely clear, that certainly I'm willing to consider other impartial expert testimony on what are standards, what are norms, what would be expected under as close to these circumstances as possible. But my preference, and that would be very helpful, but my preference is to, if possible, substantiate actual production on a well-by-well basis.
Thanks, Commissioner Ackerman. And I agree. I don't want to necessarily say just come back to us on production numbers. I agree that that's admittedly where I am. Verification of what production is actually occurring here, because I think that will kind of show what edge of that band we're on, the low end versus the high end of the valuations. But I don't want to necessarily limit it to production numbers, as Commissioner Ackerman said. I think some kind of testimony about this is the best way to provide such information would be helpful as well. But Commissioner Oath or Commissioner Messner, do you have any thoughts on additional information that you would want to see? Commissioner Messner.
I mean, I'll start by saying that I've made my decision based on the information that's provided. But I think if there's additional information that wants to get developed in order to help others make a determination, then specific monitoring of production on individual wells over a 3-month period with, daily production numbers would, for me, be the cleanest and most certain determination of production in those particular wells. Not an allocation formula utilized at a production facility, but rather the specific testing and monitoring of production at the flow lines leaving wells. And so whether that happens by a third party, whether that happens by the operator, I think one of the challenges is that the operator, in the structure that they utilize, provides most of its supporting operations. And so therefore, if there are questions by commissioners about the validity of the information that's been provided, if it's provided again by the operator, even if there's independent monitoring on there without a third-party verification, the same questions, I assume, would arise. And so I think a third-party verification of production into individual well facilities utilizing individual well testing or monitoring over a 3-month period would be the most appropriate way of gaining that information. I think testimony from staff to share, what their experience is, because we have staff with decades of experience in the spindle field looking at production numbers. I think utilizing that expertise and that experience, as support for any decisions that the commission making makes sense as well.
Thank you for that, Commissioner Oath. Any other thoughts?
No, I mean, I think if we can require that, that would be extremely beneficial.
If that's the case, I think that, and Commissioner Messner, with respect to what you just said there as well, I agree with you. I think if it's not 3 months, I'd want to know what the appropriate time is. If they have it going in the test separator for a week, if that's sufficient to show, I would hope that they would provide some sort of evidence, testimony, argument as to why that is appropriate. I guess I'd say, well, I think what you're asking for is appropriate. I don't want to, I guess I'd leave it up to the operator to kind of provide what they want to provide, what they think is appropriate to show us. And so I think the motion I would make would be to continue this to a date not certain, have the parties work with the hearing officer to try and figure out that date, at which time they provide additional information. And with respect to what AAG Davenport suggested, the specific information we are looking for would be production information, verification of the production information, ideally from a sufficient amount of time to prove production, and also ideally verified by an independent third party. But I think I'd leave it up to if KPK wants to just try and present 2 days information and say that's sufficient. I think that's their own risk and kind of putting it in their own hands. But I think that's the motion I would make. Commissioner Oath.
Never mind. I have a discussion item, but I will wait to see if you get a second.
Well, I'm not seeing a second. So does somebody want to make a different motion?
Well, I think one thing that occurred to me as you said that was if we just are leaving it up to KPK, we may end up right back where we are. You're right, if it's not sufficient information. And so I think that was kind of that was going to be my comment.
Commissioner Ackerman.
Thanks, Mr. Chair, and that's the reason for lack of second exactly. And so I appreciate Commissioner Oath's comments, and I wonder if we could just modify that motion to require third-party verification. And I think maybe we might need some counsel from our counselor on
and potentially a period of time, right? Because with the example Commissioner Cross mentioned of if we get 3, very little data or just one more data point, is that really enough to evaluate?
And part of the reason I didn't want to put a certain amount of time on it is, as Commissioner Messner indicated as well, I don't know if our own staff would say a week may be enough, or it's appropriate to look at an entire month's production, or it's more appropriate to look at 3 months production. I don't know what they would say the correct number is for that. So if a week is appropriate, or if 1 month is appropriate, I don't want to say 3 months when 1 month would have been sufficient as well. But I'm certainly okay with the independent verification. Commissioner Messner.
So I personally don't have a problem with what's being discussed here. I do have so I am a little concerned. I mean, I would like to know this information, so don't get me wrong, I want to know this information. It feels not clean. To me, the cleanest thing to do here is we have a tie. And we're going to have a tie, I think, no matter what motion we make as far as on the merits of the case. And we have another commissioner that can come in here and get up to speed and make a determination or be involved, I think, with, deliberative thoughts and an ultimate vote on this. That may be the cleanest way to approach this versus trying to provide a condition like this, although I have to admit I like this condition. But I would be curious, AG Davenport, whether you can provide thoughts on this from a legal standpoint, either in open session here or in executive session, as far as the legal considerations of either looking at a condition of approval like this versus, other potential approaches from a legal standpoint.
Yeah, I appreciate the opportunity to provide my thoughts. I'm struggling a little bit with the concept of a third party verification, in the sense that who provides that third party verification, and how that works exactly. But that aside, I understand the discussion to be there's significant interest in obtaining more production data. And I don't know if that means you're interested in seeing, it sounds like the interest is in seeing additional months of production data. Or if that is simply a verification other than just what has been reported to ECMC. If there's, for example, other records KPK has regarding what their production thus far has been from these wells, I think you can ask for additional information that the parties have, and whether or not you want to extend it to a certain number of months, perhaps it's appropriate to have a discussion with the parties. I don't know if staff's available to discuss this either right now, but it sounds like we have a lot of questions about how long is long enough. Do we just leave that up to the parties? My suggestion would be I think, have a discussion about specifically what information you're interested in seeing. I have a question about how, as I said, the third party verification would work exactly. And I think it's possible that, given the information, that staff could serve as reviewing the information and providing their opinion on that. I mean, staff at this point only knows what's been reported to ECMC. So if we're talking about just production figures, staff at this point has to rely on what's been reported or what's been put into the record here. If you're looking for additional information, I assume there's internal documents that have more information. I don't know that for sure. Perhaps visiting with counsel for the parties makes sense at some point about what information there's available to continue to provide, how long, that kind of thing, if you're interested in that. My main advice is clarity is the most important thing here at this point, probably. I think you can request or require additional information from the parties to make your determination. And so having a discussion about exactly what you're thinking you'll need and providing direction to the parties on what you want to see. But those are my thoughts right now. I don't know how helpful that is, or if that answers any of your questions, Commissioner Messner.
Commissioner Messner.
Go ahead, Commissioner Oath.
Oh, no, that's okay. I'm jumping in because he was responding to your comment and question.
Well, so what I'm hearing you say, AG Davenport, is, well, I suggested two different things. So one, if we were to proceed with a condition of approval or something like that, what are some of the legal challenges or things that we need to work out? And I think I've heard you state that we need as much clarity as possible and specificity as possible coming from a direction from here. Could also then go to a hearing officer to work out some of the details. I think I've heard you say as well, once we provide a certain amount of direction as the hearing officer works with the parties to determine what that means. I think my other question was, and I am prepared to make a motion on this, is to continue this until we have a full commission and Chair Robbins has the ability to come up to speed on the proceedings and then make it deliberations and votes on the merits that have been provided here. As that's probably the cleanest way to approach it, in my opinion. But I appreciate the.
Yeah, my apologies for not responding to that particular point. That's certainly an option as well. I mean, maybe perhaps a continuance. It's quite a lot of material to get through, so maybe not just a continuance until next week, but a continuance for a couple of weeks or something like that might be. If that's what the commission would like to do, my only recommendation is let's give Chairman Robbins a little bit of time to work through the issues and to review all of the material.
So before I make that motion, I'm happy to hear from other commissioners to further the condition of approval concept. If they would like to do that, I'll throw my 2 cents in that if we are going to consider a condition of approval that would require additional verification, that once again, that what needs to occur is individual well testing over an appropriate amount of time, at least a month, ideally more than that, that would be provided to ECMC by the operator and reviewed and verified by ECMC staff that they think, well, and to provide ECMC staff to provide their opinion on that new testing that would be developed at the individual wellheads and not a reliance on any kind of allocation formulas or previous reporting criteria that had been utilized by the operator that they may be able to provide from the past.
Commissioner Ackerman.
Thank you. As I understood that, it might be a bit of a combination of the two options, which is to develop that information and then schedule for a time when we have 5 commissioners, and I agree with that. And I just wanted to add, or at least reiterate, my concurrence is based largely upon, I do think, at least as one commissioner, this decision could go either way for me based upon the actual numbers. And so I think this is a very salient point and a reasonable reason to postpone and examine further. As the only finding that I made today was simply that the applicant didn't prove by preponderance of the evidence that those numbers were wrong. I do think that an actual examination of the numbers would be very informative as to how we make a decision going forward. I think it's a great basis for continuance.
Commissioner Oath, additional thoughts? Okay. I like Commissioner Ackerman's idea of maybe combining those. So let me see if I can put this a little better this time. I would move for a continuance to a date uncertain, during which time I would instruct the operator to gather additional production data, including additional production tests, and request that staff also provide testimony on the validity of the production tests that occurred. Commissioner Ackerman.
Mr. Chair, I wonder if you'd be open to a modification that would also include testing over an appropriate period of time as
Yes,
informed by staff.
yes. So
If so,
modified.
I'll second. If so, I'll second.
Commissioner Messner.
So I think two things are missing there. One is individual wells, right? So the testing associated with a production facility and an application of an allocation factor, I think, is unhelpful in this situation. So I'd love to see specificity associated with the production testing at each individual well. And I think that I said a second thing, but now I can't remember what it is. So I'll stick with the one for right now.
I would modify to make it with that specificity.
Second.
Commissioner O.
And I just, so if I've got this right, it's a motion to continue to a date to be determined through discussion with the hearing officer and the parties and staff. And there's instruction to KPK to gather additional production data, including additional production tests at each individual well over a certain period of time, and that period of time is also to be determined, I think, through discussions with the hearing officer, staff, and the parties.
Yes, and to get mainly for staff's input on what the appropriate amount of time is and whether the production methodology, the production testing methodology is appropriate.
Okay. Great. And then we're requesting that staff then also provides us testimony on the validity of the production testing that occurred. Okay. All right. Thank you.
Additional comments or deliberations on that motion? All those in favor of that motion signify by saying aye.
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 Any opposed? Okay, that motion passes. Okay, that is the end of our agenda on the docket today. Realize it is a bit muddy, but I appreciate all the hard work and testimony provided by the parties. And thank you to my fellow commissioners for the effort put into this as well. As everyone listening in can see, it's obviously a very difficult situation and something that is an important topic for the state of Colorado and for the stakeholders listening in as well. So thank you everyone for that, and I would move to adjourn.
Second.
All those in favor signify by saying aye.
Aye.
All right. Thanks, everyone.